I worked with all the international clients in the oil and gas space, electricity space, so many other different facets of life. But everywhere, whether you deliver at the end of the day or you don't deliver, the dispute is going to be inevitable. So if it is an international context, that's called international dispute. There are various mechanisms with which we can go about it. There are multiple schools which can settle this kind of a disputes, starting with the ICC, LCIA at London, ICC at Paris, SIAC of Singapore, Hong Kong International Arbitration Center. Like that, there are various schools and various facets through which one can go for the arbitration. But as far as India is concerned, now I think we are into our late stage of our maturity in terms of catering to the global needs of international clients. So obviously we need to have a kind of a mechanism in place to ensure that the international arbitrations are centered in India, if not elsewhere. Before I get into the merits part of it, I'll just give you one simple example as to why India should be the centerpiece for such international arbitration. I'll just take a nominal dispute of 100 crore dispute settlement in a London jurisdiction. Let's say that we agreed for a 100 crore dispute in a London jurisdiction. I'm using a term called LCIA. Look at the kind of a legal hours the advocates will have to put in, minimum of 2,000 hours for a 100 crore dispute at the rate of 150 pounds an hour with 2,000 hours of input. The arbitrator's fee, considering that there are 3 arbitrators, and the institutional fee, which is about another 1,000 pounds, all put together, my estimation and my experience for a 100 crore dispute in a London jurisdiction is not less than 5 crores. Okay. So that's a kind of a simple arithmetic it is. How many Indian companies can afford to do this kind of a cost? And remember, the dispute is not going to be won once you start a contract. There can be multiple disputes. There can be multiple arbitrations. So how much of it, the effort and time you need to take in terms of traveling to London, being there, your expenses are not computed, etc., etc. But the cost of the very dispute settlement itself becomes about a substantive amount. I think that's one of the foremost reasons why we, the Indians, being very cost conscious, need to think about the India-centric international arbitration. I think that's a theme with which I will start my today's little introductory part of it. Before the people who are present, some of the key people who are present in this webinar, and Mr. Ravi Shankar in particular, and Mr. Manish Bakshi, who himself is running an institution, I'm a minion. Let me admit that I'm a minion. But I am good because I have burnt all my hands. It's not that I'm successful everywhere. I've lost many a times. So why I have lost, etc., being apart, how much of it I can really ring fence my risks is what it makes India-centric arbitration a key success imperative. Now let's go back a little in historic times. There were times prior to 1996, it's a history. When the Arbitration Conciliation Act of 1996 has not come, it was a history. Let's not talk about it. But when 1996 ancestral model based arbitration law has come into India and it has been enacted, it tested the waters as to how much we are in sync with the world in terms of arbitration settlements and disputes. Yes, there are some flaws. There are some deficiencies. I think once you travel the journey, today we are starting on Shramik trains. Once the first train started, it became a major activity as to how to enter the train, how to enter the airport, etc., etc. Once a few flights take off, obviously you know the risk and you do the de minimis. In a similar way, when 1996 enactment has come, it has taken a little shape in terms of how well we are in sync with the world arbitration law. Huge deficiencies are observed. Between 92 and particularly between 2012 and 2019, when the arbitration law has been 1996 Act has been put to test to various courts, I think quite a few things have emanated. I'm still not referring to 2015 amendment and 2019 amendment. But what the Supreme Court has said in quite a few instances is that there are many judgments which they have delivered, particularly on the seat-centric aspect of law in arbitration. That seat-centric has something which is like a kind of a monster or a kind of a scary object or a thing which one need to live with it. The seat became a kind of a major scope for it. Second most important thing which was bothering till then is the public policy. The public policy is anything and everything till one point of time, till a Supreme Court has put a restrictions as what can be a public policy. The third most important thing is that Supreme Court has come out with enactments that even non-signatories to the arbitration agreement can also go through the arbitration process, because that is something which is really result oriented. And the trivial dispute like allegations of fraud, they are also can be arbitrable. I think these are the Supreme Court directives which are being given from time to time to set right our legislative path in sync with international arbitration and in sync with the international law. I think this is a little context setting. Then came the 2015 amendment, in which the strict timelines for deliverance of the arbitral award have been fixed of, let's say, 12 months or 18 months. And that has gone through the test. And the arbitrator's fee, so many other aspects of 2015 has been touched. Then still there were some deficiencies. And Justice B.N. Sri Krishna committee has finally come with the 2019 kind of an enactment. And we have 2019 kind of an enactment to support, which he has given, which became the basis of law. Now 2019 Act, in the sense, though it's an amendment, it's a kind of an act by itself, is the one which is standing like a robust platform today for us to take off in international law as far as the arbitration is concerned, arbitration law, where India can be centric. The most important thing is that it has given recognition to an arbitration institution. And that's where we are in the presence of one of the arbitrational institutions chief today. So one of the arbitrations, and the Supreme Court and the High Court have been given power to have a kind of a grading or to kind of a go through one of the institutions or the arbitral institutions. I think these are the little facets. I think when we start our journey, when we commence our journey, particularly in international arbitration, what is so comfortable at London and what is it we don't have it here? Today you have an excellent law. You have the topmost counsels who can guide you. Your costs are 1/50th of what you're going to spend in London. And you have the access to Mr. Ravi Shankar or whomsoever it may be, your own counsels on the back end, your own people, etc., etc. So this be the thing. I think we created a platform. What we need to create is a kind of a trust. How well we deliver depends on how well we succeed. The moment we start delivering the things based on our experience, I think that's going to give us a kind of a much more credibility. There are 3-4 important initiatives. I thought I would once again dwell with the younger participants crowd in this webinar, which I touched upon about the cost part of it. Second is the efficiency. Let us look at the efficiency. If every time we go out of India, either to Singapore or Hong Kong or London or Paris, engage the lawyers and engage the QCs, then where is the question of India being developing, and you and I are a part of the system, and we need to get ourselves promoted, and we ourselves need to have the kind of a aura or the kind of a clarity going forward into the future. We need to be equally experts at law. There is a lot of young talent pool that we need to continuously promote as such. So that be the imperative. I think we need to make it more India-centric. In all the contracts which you enter into or execute in the form of an international contract, try to put in as India-centric arbitration or India-centric place as a seat of arbitration. I think that's one of the first imperatives for the community to grow, for all of us to grow, and for our system to kind of develop and generate Harish Salves, the celebrated Harish Salves, the celebrated people who are there in the field, to be brought into India. Today, Mr. Harish Salves has migrated to London. He's staying in London most of the time. But let's have our own Harish Salves. I'm sure that we have about 1,000 people who are here, who will be in this country, who can very soon spring up to that kind of a surprise as such. Third is that once we start experiencing the difficulties in terms of an institution, the timelines, the cost, and the speciality of advice which is being given from time to time, I think that's where we can improve our systems. The systems cannot improve out of imagination. Every system will have to improve out of going through the path. I think the path gives the kind of an opportunity for us to really refine the system. This FIDA web series is a little eye-opener. You'll be surprised. I'll be one of the participants in quite a few days. I'll be joining silently. Thanks to Ravi and he's like a brother to me, and Ravi is great expertise. That's something which I would like to listen myself, because always to freshen up the mind is something which is very good at. So I think this is what, as Indians, we need to have this kind of a promotion. And we need to set up institutions. Today, why are we talking about SIAC, LCIA, ICC, HK, Chamber of Law, etc.? Why are we talking about these things? Even in India, there are institutions which have already been there. And let's create more institutions so that amongst the institutions, there is a kind of a competitiveness. And amongst the institutions, there is a kind of a refinement which happens. And ultimately, we are the biggest beneficiaries. I can tell you, the cost part of it, or the speed part of the judgment, or the dispute resolution, that is something which is key and imperative. And today, we have a talent pool of people who can be expert witnesses. Why I'm stressing this point is that in Indian-centric arbitrations on the domestic side, we don't use much of this expert advice. Whereas in international context, the expert advice is something of a very key imperative. Here we have a talent pool, which we can use up, get a kind of a proper advice. If there is an insufficiency, yes, we can always import the external people. But nonetheless, this gives us the kind of a scope and ambit to redefine ourselves, reclassify ourselves, make it more approachable for the parties to really do it. So the key imperative is that we need to have a new platform to cater to the international arbitration, being the seat being that of in India, be it a Chennai, be it a Bombay, be it a Delhi, or where it may be. Let the seat be one of the India-centric. Then let's see as to how best we really refine. And with the kind of a GDP growth which we have it, we are going to be the torchbearers of the world for the next few years. And we are getting a number of seats on various international organizations. So that be the case, we should have this kind of an expertise. I think this session of Mr. Ravi, specifically to you and your team of people who are assisting you, I think I'm really fascinated with the kind of a scope and structure which you have created. Let it be a kind of a primer. It doesn't matter. Don't assume that anybody is a kind of an expert in any field as such. All of us are learners. All of us are beginners. Each problem has its own kind of a solutions. Each problem has its own learnings. I think Mr. Ravi, teach us like a primer, and we are all there at your disposal to hear it. And I'm sure that each one of you on this webinar will be immensely enriched with the kind of deliberations that are going to have. And Mr. Bakshi Saab, I can assure you that Ravi is the one who is big asset for us in this particular program and in this webinar. So once again, thank you all the participants who are here. Just take my little few words, invest in yourself in terms of time and the kind of a focus you have on Mr. Ravi's web series, and go through a few questions of Mr. Banish Baksh's organization as to how well it is going to sync with the thoughts of an international arbitration where India-centric aspects are very well captured. And then that will be a useful tool for you as the professionals, be it on the corporate side or be it on the legal fraternity. Wish you all the best, and wish you all the best, Ravi Saab and your friends.
Thank you. Thank you so much, sir. Thank you. Rohini, you have to go ahead.
Hello.
Yeah, Rohini, please go ahead.
Yes, sir. Going ahead with our webinar session today. Today's speaker is having an experience of 27 years in the field of dispute resolution. He is an arbitration lawyer handling various international and domestic arbitrations. He is also an advocate on record in the Supreme Court of India. Presenting before you, Mr. Ravi Shankar. Please, sir.
Good afternoon to all of you. First of all, let me thank our chief guest, Badrinath sir. He is very humble, but he is one of the stalwarts who have worked for almost like 2 generations in the field of dispute resolution, that too on behalf of the biggest giants of India. He is so humble, so all the young people should learn, first of all, that from him. Number 2, whenever he speaks, we all, lawyers also get a lot of tips, how the grassroots or ground level realities are there. He has such a vast experience in this field. So, sir, I really thank you for sparing your time and joining us in this program. I also thank Mr. Manish Bakshi for giving this opportunity. Now, let us proceed with the session. Friends, all of you have come here for a 5-day lecture series in which today I am going to touch the important fundamentals of the entire international arbitration, so that the next 4 days we need not go into the fundamentals again and again. Many of you know well, after the Second World War, all the developed countries were worried about the situation in the developing countries and underdeveloped countries. They all feared that there is going to be a big unrest in the world, continue to be going to be there because of the inequality in economy. So one of the important decisions taken by them was to find a mechanism to fit into the requirements of commercial people without much complexities into that. Because every one of you sitting here are aware that even a Supreme Court judgment of India doesn't have any value to enforce it in any other country. Many countries, at least I can say. There are some exceptions to that. I don't want to go into the details, but normally I'm telling. And the procedural law of each country has so much of complexities, so much of differences, so the other country's commercial person cannot understand. So the first effort, what was taken at that point of time, immediately after that in 1958, was the existing arbitration, how we can make all the countries to accept globally. That was the first attempt made by the global community of that time. You will be surprised to know that the first convention of 1958, which is famously called as New York Convention, was not even signed by US. US refused to sign it. They said, how can we accept an award that comes from India or some other country? So we won't accept it. They all waited for 10 more years, but we are one of the founding signatories of New York Convention. Today, that time New York Convention was 36 countries. Now there are about 163 countries who have adopted the New York Convention. That means New York Convention is a basis for recognition of an arbitration agreement first. If there is an arbitration agreement in a contract, any court should not look into the disputes directly, it should send it for arbitration. This was the first understanding between the countries. Number 2 was, if there is an award passed in a member country, the other countries should respect it like a court order. These are the 2 things. Let us keep it in mind. One is the arbitration agreement, recognition of an arbitration agreement. Number 2 is the recognizing the award. Many countries had some reservations. Even we also have some reservations. So far, we have recognized only 43 countries among the member countries from whom we enforce the award. But this is the first platform which changed the dispute resolution globally. The next important issue came up before the member countries who were looking for upgradation of the arbitration process was the ununiform arbitration law. Every country had a different type of arbitration law. Every country had a different type of appointment procedure. Every country had a different type of removal of arbitrator procedure. Every country had different approach to finality of arbitration awards. So this became again a headache in the process of developing arbitration as an effective mechanism for international dispute resolution. So at that point of time, UNCITRAL came out with a model law, lobbied to all the member countries, requested them to adopt a similar law, not the exact law, at least a similar law. So as of now, about 63 countries all over the world have adopted and proudly identifying themselves as model law countries. So whichever country claims itself as the model law country has adopted the UNCITRAL model law. To some extent, at least you can say 80% of it. So the framework is same. The framework is not different. Even some countries like China or Taiwan who say that we are not a model law country, but still they also have adopted a similar law. So globally, all the strong economies, all the powerful economies have come forward to recognize the award, recognize the arbitration agreement, and also to adopt a uniform law. This is the basis of the international framework of international arbitration. So now we have a mechanism to recognize the arbitration agreement. Then we have the mechanism to recognize the award. Now we have a uniform law also. It gives some kind of a comfort. And all of you know well, each and every country recognize lawyers in appearing before the arbitrations. So the lawyer from India can appear in a US arbitration in the arbitration proceedings. Same way, even though we don't allow any foreign lawyer to appear in Indian courts, but India seated arbitrations recognize lawyers from other countries as well. We can ask a question why. Why is because in arbitration, the lawyers don't appear in the name of a lawyer or an advocate. They name themselves as the party representatives. So they are representing the parties as a party representative. So internationally, law is uniform, mechanism to enforcement is uniform, even the legal representation is almost uniform. So with this background, let us move ahead. To the next step of the arbitration. All of you know well, or many of you must have heard, understood that the basis of an arbitration is an arbitration clause. That is a contract by which parties decide that we will resolve all our disputes by way of arbitration. Once you put that in the contract, then courts will take off their hand from that case and say that, sorry, we cannot handle, you better go to an arbitration. So parties once select that private mechanism, consensual mechanism to resolve their disputes, courts are kept away. So the procedural aspects of courts are kept away. So in addition to that, which are the important things that influences an arbitration has to be incorporated into the arbitration clause. Let us see. In my opinion, there are about 6 points you should incorporate into an arbitration clause to make it a complete clause. You may ask a question, okay, I don't incorporate all the 6 items. I put only 3 of them. What will happen to the arbitration clause? Most of the time, the arbitration clause will not get frustrated. The determination of the other 3 points will be done either by the court of law or by the arbitral tribunal. But to be on the safer side, we as lawyers, we as legal advisors should advise our parties to have a complete arbitration clause. One small announcement, some of the delegates are raising your hand. I request you to hold on so that in the end of the program, we will give you time for putting your questions in the chat box. Then we can reply those questions. So please hold on till then. Please. Now, first in the arbitration clause, first thing you have to decide is the seat of arbitration. Seat of arbitration is where you want to have your arbitration by jurisdiction. It is not just a convenience, it is by jurisdiction. So for example, if you choose New Delhi as the seat of arbitration, then all the proceedings relating to that arbitration has to happen in New Delhi. It will be assumed that the New Delhi courts have the jurisdiction. Similarly, if you choose London as the seat of arbitration, then entire activity relating to the arbitration gets shifted to London. So while deciding or while advising to your party, you have to consider various aspects which we'll go into later before advising them about the seat. Number two, what we have to do is we should recommend or we should advise an arbitral institution to administer the arbitration. Arbitral institution does the work of administering or managing the arbitration, right from collecting of the fee, appointment of arbitrator. In case of challenge of arbitrator, they will deal with that. Till the award gets released, they will work like an institution administering the arbitration. For that, they charge a fee, including the arbitrator fee. We also will go into that in detail a little later. Then all of you may think, what is the substantive laws? One law, what you will be deciding is procedural law. Number two is substantive law. Number three is the law governing the arbitration agreement. Parties have international arbitration, parties have the choice or powers or autonomy to choose the laws. That means if you are a party from India and the other party is from UK, you need not choose either UK law or Indian law as the substantive law. You can choose a third law or a neutral law to be a substantive law. The convenience is the trust of both the parties. Both will feel that, okay, we are not giving any advantage to the opposite party or the other party. So the beauty of international arbitration is lying in the autonomy of the parties to choose a neutral seat as well as neutral law. So neutral seat, as I told you, parties are from, let us say, from Singapore and the other parties from India, but still they can choose a seat in Hong Kong, so that the procedural law of Hong Kong will apply to that proceeding. So you can choose a different law as the substantive law. You can also choose the seat of arbitration as a neutral seat. So the parties have the fullest liberty to choose whatever they want, but they have to choose in advance and put in the contract. That is very important. Then you have to choose the number of arbitrators. It should be preferably odd numbers. Normally 1 or 3 is the choice of the legal advice, because by majority arbitral award can be decided. So if you want a multiple arbitration arbitrator member tribunal, then you should choose a 3-member arbitration. Or if you are okay with one sole member, then you can say sole arbitrator will decide the disputes. The next important thing is about the language of arbitration. Language of arbitration is very, very important because many countries have a default language in their law. Many institutions also have a default language in their rules. To avoid that, for example, one of our parties who had a dispute in Taiwan did not incorporate their language of arbitration in the arbitration clause. So as per the Taiwanese ROC law, the Cantonese was the default language. So the entire arbitration records, even though the communications were in English, even though the contract was in English, the arbitral institution refused to accept that English can be the language of arbitration, because the local law provides default language as Cantonese. So the next important thing is language of arbitration. The last important thing is law governing the arbitration agreement. This is one aspect which you have to put. Otherwise, normally the interpretation of the arbitrators will be in favor of the seat of arbitration. They will decide that the law applicable to the seat of arbitration will be applied to the law governing the arbitration agreement also. So one more point I want to cover here is in the seat, while selecting the seat of arbitration, we have normally two wrong apprehensions. One is we put Singapore International Arbitration Center as the arbitration administering institution, and we assume that Singapore will be the seat of arbitration. It is not correct. For ICC, International Chamber of Commerce, and Singapore Arbitration Center, there is no default seat of arbitration. So you have to choose your seat of arbitration. They will administer the arbitration globally anywhere. So that is one important thing. Number two is the seat of arbitration while selecting. Please understand that procedural law comes with that. Once you select the seat of arbitration, that country's procedural law is automatically applicable. Why? Let us assume that the arbitral seat is New Delhi. When arbitral seat is New Delhi, if you are going to put in your contract, International Arbitration Act of Singapore will apply. Then it will be a chaos, because the supervising courts in Delhi cannot exercise any power from the Act of Singapore. It has to exercise its powers only from an Indian law. So it will create unnecessary complications. So keep that in mind. Now, arbitration clause we have seen. Now, next step is how or why parties select different seats. I already explained to you about the neutral seat. That neutral seat is one of the beautiful concepts which gives autonomy to the parties to select a neutral seat, either your seat nor my seat. So it can be selected by the parties. But now we are recommending that Indian seat is also becoming a very good, attractive seat for international parties. The second reason how sometimes parties choose the arbitral seat is because of the compulsion of the powerful party. That means you may be supplying some material to a party in UK. The party in UK will be forcing you that only London seat of arbitration is okay for us. So at that point of time, you can try to convince for a neutral seat. If not, you will be going by the compulsion, because finally it's your business. So the second reason why parties choose different seats is compulsion by the other party. Number three is there are some statutory limitations in some countries. For example, if you want ICC, International Chamber of Commerce, to administer an arbitration in China, they cannot administer, because China does not recognize, or China does not allow any foreign institution to administer an arbitration in China. China has more than 700 domestic arbitration centers. That means, China registered arbitration centers. Only they are allowed to administer arbitrations in China. They don't allow a foreign institution to come and administer an arbitration in China. So in such a situation, when there is a statutory limitation, if one of the parties is keen in engaging a foreign renowned international arbitration center, then they may not like to accept for a China seat. So they can go out. So these are the three, you can say, situations where parties are forced to choose a seat which is not really favorable or which is not friendly to them. I already told you that the reasons for selecting a seat, I'll just run through once again. The seat comes with the procedural law. That means if you select Delhi or Bombay or Bangalore as a seat, then automatically you get the applicability of Arbitration and Conciliation Act 1996 of India as the procedural law. So that comes with the seat. Number two, the supervising courts are the courts which are having jurisdiction over that place. For example, Bangalore seat means Bangalore commercial courts will have the jurisdiction normally. But if in case of international arbitrations, all high courts have the powers to supervise. So the third importance will be is the seat. While you are selecting, you should not only look into the law, you should not only look into the cost, you should not only look into the friendly nature of supervising courts, you should also ensure that the seat is a signatory of New York Convention. I already explained to you, if a seat is arising out of a New York Convention state, then that seat gets the power to get enforced in many other countries of the world. You also know that one single international arbitration award can be enforced in many other countries also. Same award till the recovery or satisfaction of that award. So it is very, very important to choose a seat which is a New York Convention signatory. As I told you earlier, these points we have already explained. Procedural law is one of the reasons for which a seat is selected. New York Convention is another reason. Then what are the things happening in a seat includes appointment of arbitrators, supervising courts, finality of awards, and enforcement. We will go step by step. Now, some of the delegates are from overseas. So for them, many of them, this may be a surprise that India has more ad hoc arbitrations than institutional arbitrations. We can say 90% of the arbitrations happening in India are only ad hoc arbitrations and not administered by any institution. So the clause will be very simple. Parties shall resolve their disputes by way of an arbitration. This is how the clauses are made. In some clauses, they put just number of arbitrators. This is how clauses are made. So in such a situation, what happens is no arbitral institution will administer the arbitration. There will be no arbitration rules which will be administered, which will be governing that arbitration. Number three, fees also is not fixed. So now let us see what happens if an arbitral institution is not selected. If you select an arbitral institution and put it in your class, then you need not go to a court of law to get an arbitrator appointed. If the institution is selected, you have to just go to the registrar or send an email to the registrar producing your arbitration agreement and a brief description of disputes and request them to initiate the arbitration proceedings. It is very simple. The institution will immediately start the process and go ahead. But when we don't do that, we have to go to the Supreme Court of India in the case of international arbitration because they only have the power to appoint a sole arbitrator. If there is a 3-member panel, it is okay. Both the parties will appoint each one, and then both the arbitrators will select the neutral or the chairman of the arbitral tribunal. Then you need not go to court. If it is a sole arbitrator or one arbitrator, otherwise, sometimes parties won't cooperate. You will be appointing your nominee arbitrator. Opposite party will delay the process and they may not appoint. Sometimes both the nominee arbitrators won't be able to select or finalize a presiding arbitrator. In both the occasions, again, you have to go to Supreme Court of India for getting that vacancy filled up. So to avoid that, preferably, you should choose an arbitral institution. Arbitral institution is a professionally managed institution who are aware and who are governed by a transparent rules which are informed to you in advance. In any arbitral institution's website, you go and see, you will see a fee calculator. There will be a fee schedule. So you know what is your dispute value, what will be the approximate expenses at the end of the process. But in an ad hoc arbitration, the arbitrator will fix his own fees. Many of you might have heard that some of the arbitrators fix exorbitant fee, like per hearing 5 lakhs, per hearing 3 lakhs, reading fee, writing fee, so many other fees comes in. And parties end up in paying crores of rupees in paying the arbitrator fee. And above all, you will not be able to predict what is going to be the full cost of the arbitration. So the fees will be determined by the institution, rules will be transparent, and they will also administer. So it is better to switch over to institutional arbitration. So you can advise your parties, your clients to switch over to institution administered arbitration process, which is very efficient, much better than the ad hoc arbitration. So now we have to see if we are seating an arbitration in India, how it will be governed, what are the procedures, what are the significant features in Indian procedural law. So this chart shows the history of development of Indian arbitration law. First, we had a 1940 Arbitration Act, which was a pre-model law legislation. And there were arbitrations happening for 10 years, 15 years, with a lot of interferences from the courts. But in 1996, India adopted a new law, which is called as Arbitration and Conciliation Act, which is similar, 85% similar to UNTITLed model law. So it is an internationally understandable model law. So after a few years, we also realized that there are certain issues arising out of the 1996 law. That is, India courts recognized the one-sided arbitration clauses. That means parties can authorize one of the parties to appoint the arbitrator. This was a negative aspect, and then in each stage arbitration was consuming a lot of time, and courts were interfering in a big way. So all these things were further fine-tuned in the 2015 Act. And the 2019 amendment, that came into force in 2020, there are certain more efforts taken to institutionalize the arbitration and prescribing the qualifications for the arbitration. In this stage, in the year 2015, one important thing which happened was the courts were authorized to delegate their powers of appointing the arbitrators to the arbitral institutions. That means the courts will find out the arbitral institutions and empower them with the authority to appoint arbitrators. Earlier, for domestic arbitration, the appointing authority was High Court. For international commercial arbitration, the appointing authority was Supreme Court. After 2015 Act, this power was delegated, or the High Courts had the power, Supreme Court had the power to delegate the powers to an institution. Now in 2019 amendments, these are further fine-tuned, and they have now stated that High Courts can empanel or create a panel of arbitral institutions to do this job of appointment. So this is a welcome step by which arbitral institutions are coming into place. They are going to be recognized by the High Courts and Supreme Court to administer arbitrations. So this is a welcome step. And in 2019 amendment, one more important thing which came in was Arbitration Council of India. This Arbitration Council of India is going to regulate the arbitral institutions, prescribe qualification for arbitrators, ensure training for arbitrators, and classify the training institutions for arbitration related education. So it is going to make a revolutionary change in India. So the students and the young lawyers who are here should understand that arbitration is going to give a lot of opportunity for all of you in future. Now let us understand the 1996 Act. 1996 Act expressly excludes the procedural laws of Indian courts. The procedural laws are what? Code of Civil Procedure and Evidence Act prescribe the procedure for courts to administer their cases. Both are expressly excluded. That means nobody can say, come and say in the arbitration that you have to follow CPC. Nobody can come and say that you have to follow the Evidence Act. Then who will decide the procedure? Procedure can be decided by parties. You have to understand that parties have the supreme autonomy to decide the procedure. Parties can decide it will be only a paper arbitration. There will be no oral hearing. We will submit the papers to the arbitrator, whatever decision he gives is final. Yes, final. Parties can even fix the fees in the arbitration clause. Parties can prescribe the qualification for the arbitrators. Everything parties can decide. If parties fail to decide, then you have to go to the courts or the arbitrator to decide the procedure, not the courts, I'm sorry. If parties differ from deciding the procedure, then arbitrator will decide how the process will be taken, how the pleadings will be completed, how evidences will be taken, how the oral hearings will happen. All those things will be decided by the arbitral tribunal in the first hearing. So the procedural law is out. Only the procedure prescribed by either the parties or the arbitral institution or by the arbitrator will come into place. Now you may ask another question is, what about limitation? Limitation Act is applicable because in any country it is treated as part of the procedural law. So it is a part of procedural law. So whichever seat you are choosing, if you choose a Singapore, the Limitation Act of Singapore will apply. In the same way, if you choose a seat of India, Limitation Law of India will apply. What about the substantive laws? Substantive laws, as I told you, substantive laws are like company law, contract law, partnership law, whatever law is required to decide the dispute between the parties is called substantive law. Those laws will be applicable as decided by the parties. For example, you can put the seat of arbitration in Delhi and you can choose substantive law of England as the governing substantive law. In that case, what will happen? Indian procedural law, that is arbitration law, will apply. Limitation law, Indian law will apply. But with regard to the contract law, company law, specific relief act, or whatever it is, for that you have to choose the English law as the basis. So when you are deciding your seat, when you are deciding your applicable laws, you keep this in mind that procedural law and seat are same, substantive law, law governing the arbitration agreement can be different. So when you are choosing the Indian law, this is what will happen, Indian seat. Now, special features of the procedural law in India. In India, and it is India-centric lecture. So what are the important procedural law aspects of the Indian arbitration law? First thing is, one of the finest distinction I can say Indian law has is independence and impartiality of the arbitrators. There is a rules called in IBA rules of conflict in international arbitration, which provided 3 lists: green list, orange list, and red list, to see whether the arbitrator appointed is in any way related to the parties or related to the counsels appearing in the matter. So this is to ensure impartiality. In case if a party is having a financial relationship with one of the parties, then there can be a reasonable apprehension from the other party that we may not get a equal treatment. So such arbitrators cannot be allowed to determine the disputes. So internationally, IBA rules prescribe that if the arbitrator relationship with the party or with the client, with the lawyer falls in green list, then absolutely there is no problem. They can continue. If it falls in orange list, then both the parties have to expressly agree or waive off their right to object. Then they can continue. A red list is completely prohibited. Similarly, Indian law provides for 3 lists in Schedule 5 and 7. So those clearly makes a distinction between the prohibited relationship and the doubtful relationships. So if you go through those relationships, you will understand the beauty of the Indian law with regard to independence and impartiality. Then another important aspect is, which many countries do not have, is interim orders in support of foreign seated arbitrations. If there is an arbitration happening in Singapore and there is a property in Delhi, you can get an injunction in Delhi court not to sell it till the arbitration in Singapore is over. So this is one important aspect which helps the international arbitrations. And reduced scope of public policy. As Mr. Durusala was very nicely explaining, public policy is an unruly horse. Every court, every country tries to expand the public policy interpretation and try to reappreciate the award. So time and again, Supreme Court of India is trying to restrict again and again and bring the public policy to a narrow situation in international commercial arbitration. This topic we will discuss on the 3rd day in detail, so I'm not going into the details now. Timelines. Now, for every stage of arbitration, there is a timeline prescribed in our Indian law that if you take a interim protection from the court, then you have to start the proceeding within 2 months. Same way, an arbitration has to be get concluded from the date of formation of the tribunal within 18 months. And the fast track arbitration should be concluded in 6 months. So these kind of timelines have brought in a lot of discipline in India. But unfortunately, in the recent amendment, the international commercial arbitrations are excluded from these timelines, which is a little bit unfortunate situation. For domestic arbitrations, these timelines are given. And enforcement of orders. And the enforcement of interim orders also has become a part of the new law, which is another important development by which arbitral tribunals' interim orders are enforceable like court orders now. Now, the arbitral institutions, let me quickly go. And as I told you, in countries like China, foreign arbitral institutions are not allowed to administer arbitrations in that country. But in India, any international arbitration institution can administer arbitrations. This is very important. For example, ICC can administer arbitration in India. So if any of you have a doubt that Indian institutions cannot administer, then you can choose any foreign institution also like SAAC or ICC who will come and administer your arbitration in India. But only now an additional condition is put that the institution has to get registered before the Supreme Court of India to administer international arbitrations. That will happen like a procedure. There are many Indian international arbitration institutions also are coming up. Delhi International Arbitration Center, Indian Council of Arbitration, Mumbai Center of International Arbitration, IDAC India. There is an Nani Palkiwala International Institute of Arbitration. Many institutions are coming up who are delivering fantastic international class services. So you can choose Indian arbitral institutions who are as efficient as foreign institutions are. And in terms of the fees, they are much, much lower than the foreign institutions. Now the next step is supervising courts. Okay, we have seen the legal provisions. What supervising courts are doing? Supervising courts have the powers to appoint the arbitrators, give interim orders, removal of arbitrators, and the challenge of awards. These are the main things. And interim orders, sometimes jurisdiction will differ. Otherwise, appointment till the challenge, same court will have the power. For example, if seat of arbitration is Mumbai, then for an appointment of arbitrator, in case of an international commercial arbitration, you have to go to Supreme Court. If it is a domestic arbitration, you have to go to Mumbai High Court. And you will challenge, if there is a dispute with regard to the removal of arbitrators, then in the Mumbai High Court only. Then again, challenge of the award also, you have to go to Mumbai High Court. Here, one thing I want to make it clear is, if you are going for an institution, then appointment of arbitrator, you need not go to the Supreme Court or High Court. You can do it in your in the institution only. Same way, for removal of arbitrators, there are many institutions have inbuilt mechanism. So for this also, you need not go to courts. Other advantages of Indian seat is, one is mandatory pre-deposit. This is a very, very attractive proposition now. In nowhere in the world it is available. That means if any party, losing party, want to challenge an arbitral award and stop enforcement of the arbitral award, then they have to make a mandatory pre-deposit. That means if you have an award of 100 crores, at least you have to pay 75% of it, deposit in the court before challenging it. So this brings in, this reduces a lot of unnecessary challenges to the arbitration awards, and it expedites the enforcement of the arbitration award also. So it is a very, very important thing. So while you negotiating the arbitration agreement with foreign parties, you can show this clause, which will be very attractive for them. Then, as I told you already, one-sided arbitration agreements are not enforceable in India. Now, by law, confidentiality is also ensured in arbitration proceedings. Now, friends, finally, I conclude by this. I recommend India seat because India is a model law country. India has signed a New York Convention, so anywhere you can enforce the award. And there are timelines for various activities relating to arbitration in India. And foreign parties, foreign institutions are allowed to administer arbitrations in India. And then because of the pre-deposit compulsion by law, the unnecessary challenge to the arbitration award are very, very reduced. So by this, I am closing my presentation. Now the participants who are having questions can post their questions in the chat box so that the rest of the time we can use for answering the questions. We can share the presentation. You please send a mail. Some of you are asking for the presentation. You send a mail to the administrator. They will do that. Jay Krishnan, you can type your question in the chat box, please. What is the scope of online dispute resolution in India? We have a separate session, Ruchi Bali, on the last day about online dispute resolution. It is very well practical in India. Even IDAC India has brought in an online platform by which they are going to administer not only document-only arbitration, but also with proper oral hearing of arbitration. Online arbitrations are going to come. There are few arbitration centers who are getting ready for that. We will discuss it on the 5th day. What is the status of Indian Council of Arbitration? Indian Council of Arbitration is an arbitral institution started by FICCI and administered by FICCI. They are one of the oldest arbitral institutions, actually started by Ministry of Commerce and now administered by FICCI. So it is one of the nice, well-administered institutions. So many questions are coming. Can we challenge the order of? A little slow. I can read the questions. Can we challenge the order of the Indian arbitral decision in the Supreme Court or in any other countries? Yes, an arbitral award can be challenged in the supervising court. As I told you, an arbitration award which is delivered in Delhi can be challenged in the High Court of Delhi on very restricted grounds. The grounds we will be discussing on the third day, but it is not like a regular appeal. It is having a lot of restrictions. So government as well as the courts are trying to ensure and give lot of respect to the arbitral awards. Administrator can unmute Badrinath sir also. He can answer some of the questions. Sir, one question is, what is the difference between lex arbitri and the venue in respect of Indian laws? You have to unmute. I'm unmuting. They are talking about the seat and the venue difference, sir. Can you a little bit?
I think you are better place to explain that.
Okay. Friends, and while you are putting a seat of arbitration has a jurisdictional value. That means, as I told you, if you put a name of a city, then the court having jurisdiction over the city will be a supervising court. But if venue can be in different places also. For example, there is a dispute between a Chinese party and Indian party, and they have a plant or a manufacturing plant in, let us say, Dubai. So some of the hearings they can keep in Dubai to inspect the plant or get some witnesses or some kind of things. That is called venue. So that is only for a convenience of the hearings of arbitration. It doesn't have any jurisdiction value. So you need not put the venue in the arbitration class. Please put seat only. Venue can be decided by the arbitrator in consultation with the parties. So don't use the word venue, which creates a lot of confusion.
Perfect.
Any other questions? Sir, question is, unilateral appointment of arbitrator is possible. It was possible as per Indian law, but as per a recent judgment of the Supreme Court, it is very clearly pronounced that one of the parties cannot be given the authority to appoint an arbitrator. So if any of you are having such a clause in which one of the parties authorized to appoint an arbitrator, that portion of the arbitration clause becomes invalid, and you can apply to the High Court and seek for an appointment of a neutral arbitrator. What is your view about MedArb? Sir, would you like to?
Which one? What is that?
They are doing, sir, MedArb. Arbitration, then it goes to mediation and becomes an arbitration.
Well, all I can say about this is mediation. Initially, it is referred to arbitration. Like in a typical LCA or whatever it may be, there is still a possibility and a window for a mediation to come back with a settlement when the arbitration process is on. It is still possible. But usually what happens is that there is a mediation which takes place, and failing in the mediation, that goes to arbitration. But here, after the commencement of an arbitration, still there will be a window made available for the kind of a mediation, so that assume for a moment there are about 10 claims and there are about 10 counterclaims. So when all the 20 claims will go to the 10 plus 10 will go to the arbitration part of it. Then there is a window of a mediation which happens, because once the kind of a process is on and we know the strengths and weaknesses respectively, I would decide the party 1 will have only 5 residual claims and party B will have about 6 residual counterclaims. So I think that kind of a mediation is possible. Then these things get precipitated to the arbitration back.
Thank you, sir. Thank you for the answer. Now, what is the primary step we follow if a person wants to go for an arbitration? The first step is you have to issue a notice of arbitration, either suggesting an arbitrator or appointing an arbitrator, a nominee arbitrator if it is a 3-member arbitration tribunal. But keep it in mind that is the day on which limitation comes to an end. So you should give that notice without crossing the 3-year limit. Once you give the notice, then it has a validity of 1 month.
Mr. Ravi, I would supplement that
Yes, sir.
Sir has put the question that arbitration is not a easy option. Arbitration is the toughest option one will be exercising. So before you go for the arbitration and think about the primary steps for arbitration, think 10 times. Try to go for a conciliation or a kind of a mediation or a kind of a settlement. I think that is the first step you need to do. If you fail in all these steps, then one should think about the process of an arbitration. Because once an arbitration is triggered, then you are into a long drawn chain, which has its own kind of a mechanics and the mechanism to really unwind. It's a very difficult process. So think 10 times before you trigger the arbitration.
Thank you, sir. Now, another interesting question is, can 2 Indian origin parties opt for foreign governing law? See, there are some gray judgments which have come from some high courts, but as of now, because of Balco very clearly making it a point that Indian parties cannot try to circumvent Indian law by choosing a foreign seat. As of now, 2 Indian parties or 3 Indian parties cannot choose a foreign seat arbitration or a foreign governing law as a governing law for the administration of their arbitration. That is not possible. How much career options are available for freshers in Indian arbitration? There are lots of opportunities. Friends, one good news I will be telling you is, actually I have challenged the 2019 Arbitration Amendment Act as a party in person in Supreme Court, which is admitted by Justice Nariman, on 2 important issues. One is the qualification for the arbitrators. There is a lot of mess created in that. One of the messes, 10 years completion is required to be appointed as an arbitrator. In my opinion, it is totally unnecessary because there are a lot of small arbitrations which are going to come to the open market. Earlier, big finance companies who were having disputes of 5 lakhs, 3 lakhs, 2 lakhs were giving hundreds of cases to a same retired judge. He will sit like a court and do the arbitration and mechanically give the award, which is not possible now. If an arbitrator is appointed in more than 3 cases, party can challenge it. So it is all going to come to young lawyers. So our endeavor is to take away this 10-year prescription for qualification of arbitrators also, which in my opinion will happen at least for small size cases. So very soon you will all be getting opportunity to get appointed as arbitrators also. And as lawyers, from the young age, if you start practicing arbitration, sky is the limit. There are a lot of opportunities.
Mr. Ravi, I'll supplement this with one wonderful thought.
Yes.
That people generally have this kind of a view whether arbitration has got a kind of a career. The right question put by somebody whomsoever it be, I really appreciate the question. But look at the kind of a COVID situation which we are in at this point of time. Everything has come to a grinding halt. Every project has come to a grinding halt. Every project throws up a lots of challenges because it is not yet recognized. The COVID is not yet recognized as a kind of a force majeure situation. So we are foreseeing that there are a number of disputes which will pop up post this COVID in the next 6 months to 1 year kind of a span, which is going to be huge. In fact, there will be clogging of the system with the kind of lack of arbitrators, the number of arbitrations going up, or the kind of issues that will emanate for the dispute resolution. I think this is the right time for some of the smart young lawyers who want to make a career in arbitration as a right starting point at this point of time. And there are some focused lawyers like Mr. Ravi who have been onto arbitration predominant part of their time, about 80%, 90%, maybe I may be corrected subject to. But there are quite a few senior lawyers in the domain who have been really with the arbitration, and one can really pick and choose it as a career, because this is the right point for somebody to pick and choose it as a kind of an option.
Thank you, sir. Thank you for your comments. Now, how parties decide the qualification of arbitrator? This is one important question. Friends, the very beautiful design of arbitration is a person who is not having sometimes even a minimum legal knowledge or technical knowledge can deal with a legal issue or a technical issue, how it comes. You might have seen some retired judges getting appointed as an arbitrator in a complex infrastructure project. At this point of time, the liberty available to them and the parties have a right to examine an expert witness who is an expert in infrastructure. So the infrastructure related issues can be explained to the tribunal by an expert. So that is the facility they have in this arbitration. In the same way, an engineer sitting as an arbitrator can invite a legal expert as an expert witness to understand certain legal issues which he required to decide. So that is why you must have seen internationally there are many domain experts who are very, very popular arbitrators. So at this point of time, what you have to do is, whenever you are deciding a contract, you can see into the potential disputes that can arise, and accordingly you can decide even the qualification of an arbitrator. For example, among the 3 arbitrators, one of the arbitrator will be a person having at least 10 years exposure in the highways work. If you put like that, then definitely the institution or the parties have to find at least one person who is technically qualified to be a part of it. But you have to put in your arbitration clause this provision. That power is with the parties while deciding the arbitration clause. What is the difference between the substantive law and law governing the arbitration agreement? It's a good question, but this issue has come up only in very few occasions. One of the occasion came to the UK courts to decide whether the law governing the arbitration agreement should be lex arbitri or it should go with the substantive law. At that point of time, the court took a view that no party will enter into an arbitration agreement which may frustrate the objective of going to arbitration itself, because in that country, in Brazil, there was a law which stated that if you want to initiate an arbitration proceeding against a public sector undertaking, you require a permission from the government of Brazil before initiating such an arbitration. So at that point of time, UK courts decided that this will frustrate the whole proceeding. This will frustrate the intention of the parties to go for arbitration. So the law governing the arbitration agreement is not the law governing the procedure. It should go with the substantive law, because substantive law was selected by the parties as English law. The only thing what you can keep it in mind is, if anybody want to challenge or enforce an arbitration agreement, they have to choose the jurisdiction which is chosen by the parties, not the procedural law jurisdiction. If you put a different law for that. Otherwise, globally, the view is the law governing the arbitration agreement and the law governing the procedure, that is lex arbitri, are one and the same. What is the difference between a foreign and international arbitration? There is no foreign, I can say like this, you can say foreign seated arbitration and international arbitration. The best formulas are two. One, you can imagine that one of the parties, if it is of foreign origin, it is called international arbitration. One example is an Indian party and Samsung. If they are fighting a case, then it is international arbitration. But if an Indian contractor and Samsung India, which is an India registered company, are fighting with each other, then it is a domestic arbitration. When the arbitration is seated in a foreign country, it is foreign seated arbitration. In India also, international arbitrations can be seated. So these are the two differences.
Mr. Ravi, in the interest of everybody, I am just putting a question back to you.
Yes, sir.
That it is a dispute essentially between the two parties, which are of Indian origin.
Yes, sir.
One is an Indian origin, but the other party is a step-down subsidiary of another Indian company, which is located outside India. Say, for example, let's say that Reliance London, one of the subsidiaries, step-down subsidiaries. If the dispute happens between a subsidiary which is located outside India and that of an Indian company, how will it be treated?
It's a very interesting, complicated question also. In my opinion, it should be an international arbitration, sir. That means it should be treated as international arbitration because anyhow it is a foreign registered company. Any foreign registered companies will have their own jurisdictional value and location. So it should be an international arbitration. Sir,
is there any tested case law in this regard? Because I heard about it, something is being contested in the court. That it's a step-down subsidiary of India, but located outside, registered outside.
Interesting question, sir. I will research and get back to you.
I think this is one very interesting. And I have a generic advice for the people. I'm also flowing through the questions which have been put up on the screen.
Yes.
One generic advice to the people. I think most of them are quite as students or just passed out graduates, quite a dominant portion of this webinar. I would request them to read some of the clauses concerning the arbitration in any agreement as such. Let them pick up one of the contracts, read about an arbitration clause, and then probably, since it's going to be a 3-4 day session, obviously they can come back with a more refined kind of a questions so that it gives a kind of a practical perspective to them.
Yes, sir. Thank you. Thanks. That's a nice idea. Since we are going to meet every day, that can be done. Please clear about the mandatory pre-deposit. Friends, as I told you earlier, if you file an application under section 34 challenging an arbitration award, it gives an automatic stay. That means an enforcement cannot be proceeded against the successful party. It takes many years to get concluded, then only you can enforce. To avoid this or to stop this practice, 2015 amendment brought in a provision by which if you want to have a stay of the enforcement proceeding, then you need to make a pre-deposit like a money degree. Now awards are treated like money degrees. You know very well that when you challenge a money degree, you have to deposit substantial portion of it. Normally it is a 75% of the award amount. So similarly, that kind of an amount has to be deposited in the court, then only you will get a stay. Otherwise, the enforcement proceeding will proceed as usual. There will be no stay. I wanted to know about cost of arbitration and who bears it. There are different rules and principles followed in different jurisdictions. India recently amended and made instead of agreement between the parties earlier. What is the current position? In current position is cost follow the event. That means now Indian arbitrators have to provide sufficient costs based on the actual expenses. Now, many of the arbitral tribunals consider the arbitrator fee, arbitral institution fee, and the lawyer's fee as a cost of the arbitration. and the losing party has to proportionately accept it. After this practice and implementation of this cost procedure, now parties are also fine-tuning their claim amounts, because earlier parties used to make a claim for 100 crores and counterclaim for 200 crores. In such a situation, even if the respondent wins the case, they will also be losing the counterclaim. So they will lose the cost as well. So now parties should be careful in framing their claims so that they get the actual cost. Now, as per the current law, actual cost can be awarded to the winning party. But please provide the proper certificates, bills of the lawyers, chartered accountant certificates, payment proof, everything. Otherwise, arbitrator can reject also. So far, law students as arbitrator, that's not happened. So, but still you can convince the parties, because many of the parties have the power to appoint the arbitrator. If it is a matter which can be dealt with by you, if one of the parties have the confidence on you, they can nominate you. There is no bar.
Mr. Ravi, I'll supplement something over here.
Yes.
Like in most of the foreign institutions, as we are all aware about it, whether it is in London-based LCA or that of ICC or SASC, most of the lawyers, incidentally, they could be lawyers, but there are chartered engineers as well as accountants, etc., who are also arbitrators, depending on the kind of a commercial dispute that is arising as such. It's not necessarily a legal professional, but it can be outside the legal professional.
Yes, yes.
So what they tend to do is that if he is a legal professional, he would try to have a kind of an engineering tag-along degree to him, so that he has a better credibility acting as an arbitrator. So here, not only the law students, even in your case also, I can suggest, assuming that everybody is a lawyer, there's nothing wrong in picking up a few facets of a project management by a certified program or something else, so that when you are appointed as an arbitrator, this becomes a very efficient tool for you to be recognized in the system, that you can do a better job than an ordinary law graduate. I think that's what I would like to say. Some of the colleges in India have started this practice of engineering, 5 years engineering LLB and things like that. I think that comes in quite handy for those students to become an arbitrators, to be accepted in the system in a better way.
Thank you, sir. That's a fantastic advice. Multidisciplinary people are more wanted in arbitrations. Most of the Indian arbitrators are retired judges. How can one address conflict of interest issues between a sitting judge and a retired judge / arbitrator? See, conflict of interest is very well defined. It is not a very, can say, broad interpretation can be given. It is a very narrow interpretation, and it is covered under Schedule 5 and 7. So whichever arbitrator is appointed as an arbitrator, they have to make a declaration explaining their relationship with the parties to the arbitration, as well as the relationship with the counsels who are appearing in the matter. If it falls in Schedule 5, then it is a mandatory disqualification. If it is falls in 7, then both the parties, if any party is aggrieved, they can challenge it before the arbitrator under Section 13. The tribunal will decide whether it is really a conflict of issue or not. Even if you lose that challenge, then it can be added as one of the additional grounds while you are making a petition under Section 34 if required. But conflict of interest between a sitting judge and retired judge as an arbitrator, I don't see any difference. Only thing is sitting judges won't disclose. Arbitrators will disclose. Sir, you have anything to say on this?
No, I think the question is a little, it doesn't have the kind of a clarity, but what they're trying to say is that there can be some kind of a common parties. Will there be, say for example, the arbitrator could be son of a judge, and the party would have been somebody who has been advised by the father when he was an advocate, not before being elevated as a judge. The son knows about it. This party used to come to the dad, who is now a sitting judge. But can he be an arbitrator? Because he knows that the father is also treated the kind, and now he is also to adjudicate on this issue. So maybe that could be kind of a context which he's looking at. And today's arbitrators, I think they have a fair play because of the rules and also institutions being governed by Mr. Bakshi Saab and people like that. I think there is a discipline which is already there in the system in terms of disclosures.
Now it's 4:30. I think the questions were the other questions we will answer by a common, we'll say, we'll create a write-up and circulate to all the people. Let us wind up the session today, come tomorrow. Tomorrow we will give you a common email ID so that you can put your questions in that so that we can reply to each one of you also. Sir, thank you so much.
Mr. Ravi, I could see a lot of interest in the kind of, there are about 550 people at the peak of the session. Now it is about 442 people. That speaks about volumes, about the kind of interest people have got in this particular session.
Yes, yes, yes.
For two reasons. One, how good is arbitration? And second, how good is an arbitration as a career? I think these are the two things which are bothering quite a few people's mind.
Yes.
I can assure you that, number one, this session is going to be a very interesting session. The way in which you have showcased the themes for the 5 days. And second, it will be a wonderful opportunity for the people who want to take it up seriously. So I wish everybody best of luck.
Thank you. Thank you so much, sir. Thank you so much. Thanks to all of you.
Bakshi Saab, namaskar.
Thank you to all of you. Thank you so much. Bye, friends. Tomorrow we will catch up at 3 o'clock. Thank you all.